That case law was suddenly overturned with the 1886 Santa Clara decision. This was the Chief Justice at the time. If he were alive today, we the people could ask him what happened in 1886 and try him on our people's court of public opinion. I'll give an early example. In 1839, in the case of the Bank of Augusta versus Earl, the Supreme Court ruled that corporations might be treated as citizens in federal court, so as to hold them accountable for wrongs, but could not claim the constitutional rights of living persons. And so it went, in case after case, decade after decade, as it should have continued, except that corruption changed the game plan in 1886.
You're out of order. My name is Morrison Renwick, Chief Justice of the United States Supreme Court, 1874-1888. I was educated at Yale, Phi Beta Kappa, Skull and Bones, and I practiced law in Ohio, often in defense of railroads and big corporations. And why not? Railroads in those days were the shapers of cities, the bringers of dreams, modernizers, and wealth builders. It's true I had no judicial experience before President Grant appointed me Chief Justice, and that I was not his first choice. In fact, I was his seventh choice. Many were dubious at first, but I proved them wrong. Soon I became known as a quick study, honest and industrious to a fault, and a popular figure. I served until my sudden, unexpected death in 1888. And I can tell you that my ruling in Santa Clara was completely correct and legally unassailable.
And we are grateful for your service, Judge Waite. But I must disagree with you. Let me explain. As I was saying, we had all that standing case law establishing that corporations should not have the constitutional rights of human persons from the birth of the Republic right up through 1860 and long beyond. But then something odd happened in the 1880s, and it happened because of two results of the Civil War. What were they? First, the Civil War made railroads richer than God. Now they could get the very best lawyers, rented by the ton, to help them fight the enemy of expediency, government regulation.
It was all perfectly legal.
Of course it was. Second, the Civil War inspired Congress to write the 14th Amendment in defense of the human rights of newly freed slaves.
A good idea, but hard as hell to get approved.
Ratified in 1868, the 14th Amendment was supposed to protect freed slaves from abuse by Southern legislatures. This is what it says in Section 1, which speaks famously about due process and equal protection. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Can anyone doubt that the words of the 14th Amendment were meant to protect people, the recently freed slaves, from Southern legislatures? It is hard to imagine how a defender of original intent like Justice Scalia can claim 14th Amendment protections for corporations. Quite apart from the plight of freed slaves, those clever corporate lawyers saw the 14th Amendment as simply a handy weapon in the fight against regulation. If they could just persuade the courts to declare that corporations were persons, then corporations could evade state regulation under 14th Amendment protections, the same protections that any natural person, except a woman, of course, or a freed slave, could claim against state laws. This new kind of legal assault began right away in 1869. Hundreds of cases were brought to the court, few of them by people.
Pomeroy, you're one of the great constitutional scholars in our country. You were counsel on the San Mateo case. You were on this Santa Clara case. How do we use this to get the rights established for the railroads?
Well, Stephen, in settled jurisprudence, Article 4 of the Constitution and the 14th Amendment, citizen or person is used to mean natural persons only. Corporations are not included within their protections. But as you are determined to pursue it, this case does provide another chance. Here are my case notes with some suggestions. The 14th Amendment may prove to be the only bulwark and safeguard by which to protect the great railroad systems of the country against the spirit of communism, which is everywhere threatening their destruction or confiscation.
But the Supreme Court continued to reject the corporate claim to 14th Amendment protections. It did so as late as 1880 when it upheld a state's right to ban lotteries in Stone versus Mississippi. Isn't that right, Judge Waite? You became Chief Justice in 1874, so how did you vote in Stone versus Mississippi?
Well, yes, but that was an entirely different matter.
Don't bother. I looked it up. You not only concurred, you wrote the majority opinion. Your opinion even quoted Chief Justice Marshall. The framers of the Constitution did not intend to restrain states in the regulation of their civil institutions adopted for internal government. And the instrument they have given us is not to be so construed. You may sit down, Mr. Waite.
Any more on this subject, and you will be in contempt of court. Mr.
Waite, this is not your court. This is the court of public opinion, where free speech is the order of the day. Well, now comes the great puzzle. Why did the court suddenly do an about-face on the momentous question of corporate personhood? Were you culpable, Judge Waite, as Chief Justice? In 1886, on a simple property tax case, the railroads hired guns got their opportunity in Santa Clara County versus Southern Pacific Railroad case. This was a simple tax case about fences built along Southern Pacific's rails. It had nothing to do with corporate personhood, and yet almost any professor of constitutional law will tell you that this case was the precedent for corporate personhood. Ladies and gentlemen, it was that precedent in 1886 that eventually gave corporations the constitutional protections Congress meant for freed slaves when it wrote the 14th Amendment, and the constitutional rights that were intended by our founders for individual Americans, for we the people, those of us who are human persons, that is. It was this 1886 precedent that created the legal foundation for rights that enable today's owners of corporations to break free of regulation, avoid the monitoring of environmental protection agencies, and acquire the vast economic power that dominates our government and permeates our culture. In 1886, corporations usurped the rights of individual human persons. They have used those rights against us time and time again. Indeed, it was that precedent that gave us the Citizens United Supreme Court case in the year 2010. And you, Chief Justice Waite, were part of that theft. Wasn't it your decision in Santa Clara versus Southern Pacific that established the precedent of corporate personhood?
Absolutely not. I did nothing wrong. That was not our decision at all. Go back to school, Professor, and learn a little more court history before you slander me.
Just a moment, Your Honor. What about that famous quote of yours? It's here in a note to you from John Chandler Bancroft Davis, your court reporter in that case. It's probably no accident that Davis was a former railroad president. Well, let me refresh your memory, Chief Justice. It's dated May 25, 1886.
Yes, Davis, I believe we struck on a way to get the rights for our railroads. You can write it in the head notes. Wait raised a corporate person question in conference. But you were there. We all assented. Put it in the head notes.
So you believe that will get the 14th Amendment's application to corporations into the legal record?
Yes. I think it shall do quite nicely. After all, the railroads and big business are building this country. They need all the help they can get.
All right. I will write to wait for his concurrence. It is important that our railroads gain the rights. I fear the Lord may consign me to hell for such a remarkable falsehood.
What, Lord?
Good point.
Oh, yes, Davis's note. But that was just my passing comment, not part of the opinion. I think I told Davis it was an accurate statement of what was said in conference before the argument began. But the case did not meet the constitutional question. I left it to his discretion as I was busy with other cases.
You mean to say that your opinion in Santa Clara settled no constitutional question?
That's exactly what I mean. We ruled in favor of Southern Pacific Railroad, but very narrowly on the question of taxes. Justice Harlan wrote the majority opinion. We found that Santa Clara County had made a trivial mistake in figuring the taxes owed by the railroad. It included some fences by mistake, and that was that. We made no ruling on corporate personhood. We all knew that. Court reporter Davis knew it too, but he chose to add that bit about 14th Amendment protection